Solicitor, you are such a good person. Have the patience to hear us. During election in West Bengal.
There is no election in West Bengal.
Oh, I see. If this is the level of knowledge that emanates from the solicitor, there's nothing I can say. You're not fair. You're not fair on us.
The Honorable Chief Justice also should issue a circular that lawyers who are appearing would not discuss that matter in public forums like press conferences.
In principle, my learned friend should have no objection because he knows that that's not the law. Once a judgment is delivered, it's public property, and this court has said that once it is public property, it can be discussed. And he knows the law, but he doesn't want to reveal that he knows the law.
No, my lord. The incident in question, there is no judgment in law, and narrative building.
My learned friend is wrong. CBI furnished the second supplementary charge sheet in the proceedings emanated from FIR on 1/7/2024.
Last date 8/1/26. Concrete material found during investigation.
That's right. So that's precisely the case. That from
2026.
That means 2024. Why would you were doing nothing? Suddenly in 2026 you find material.
On the lighter vein, what Mr. Tushar Mehta is suggesting, if money is laundered only during the election, what is their fault?
There is no election, my lord.
That's why this relates to Goa.
That ongoing election. Which election?
Solicitor, you are such a good person. Have the patience to hear us.
My learned friend disarms me.
Well, you're right. There is no election in Goa.
This is not Goa. This is Delhi.
No. This is by Goa. Money transferred to Goa.
My learned friend said during election, why did you
during
go for
election in West Bengal?
There is no election in West Bengal.
Oh, I see. If this is the level of knowledge that emanates from the solicitor, there's nothing I can say. There is no election in West Bengal. Sure, it does.
He's yet to be notified what he's saying.
He can say that. He's a very precise lawyer. He's very careful with his words.
I am, my lord. Therefore, I am saying there is no election. Your premise is wrong.
Absolutely, there will be none.
My lord, only one line, my lord. Allow me to interrupt. My lord, if the ED officials go to their party office, it's not a party office. It's an office of a strategist kind of according to them. What would a normal person do? Please give me a minute. These documents have two sets.
1 second.
One, my party thinks, and another maybe else.
1 second.
Another you can go, but allow me to take my party details. You have nothing to do with this party details.
The solicitor seems to have
Just takes everything which is shown in the media with files and everything, that I have taken everything. Otherwise, if there is a scrutiny, say no, this is my party.
Everything that he says has to be accepted. Why are we here? Merely because he keeps on interfering, says what he wants to say, as if this is the gospel truth. You're not fair. You're not fair on us.
See, there is some circular issued by the Honorable Chief Justice about time schedule.
Yes. You must
should apply to
yes, and interruptions, both.
To motion hearing also.
Both.
To regular hearing.
Yes, but the Honorable Chief Justice also should issue a circular that lawyers who are appearing would not discuss that matter in public forums like press conferences. That is also
that the CBI should not be leaking information and the ED should not be leaking information.
Yes. So there is no issue
to journalists of their liking. Therefore, there should be a ban on that also.
Yes. I'm ready to show, my lord, what I have stated.
You can show it. You can show it.
This is not the
narrative.
That's why my learned friend always he's very upset at the fact that I do some program with us.
One response to Mr. Sibal, a very respected. I personally, you know, I respect him. My objection to matters of arguments being debated elsewhere is not only against Mr. Sibal.
It's also
everyone.
It's also against
who appear.
Yes.
In the matter should not give press conferences give media interviews justifying or creating a narrative. That's in principle, not in this.
In principle, my learned friend should have no objection. In principle, he should have no objection because he knows that that's not the law. Once a judgment is delivered, it's public property, and this court has said that once it is public property, it can be discussed. He knows the law, but he doesn't want to reveal that he knows the law.
No, my lord. The incident in question, there is no judgment in law, and narrative building.
My learned friend is wrong.
I leave it at that.
There is a
Can I have
I leave it at
3 minutes. I heard my lords, my lords, what my lords.
No, we have the entire, about second half bench is cancelled.
I mean, that matter, my lords, it was mentioned without telling us. That bench, Justice Amanullah and your lordship.
Sir, I do not know your loss, but your advocate on record was informed
But then
that
let
he was
me, my
present.
lord is saying something, let me
No,
respond
counsel
to
has
my lord.
He was present.
It was cancelled by the bench, by the
I see.
court, not by the any
I was
request of
told
any.
somebody mentioned it, he told us after.
No, my lord, we
Anyway.
mentioned with presence of his advocate on record,
Anyway.
with consent.
What Mr. Singhvi
I
said.
can apologize.
In fact, the court said that we'll fix a date later.
Said he should have been heard before cancelling the bench.
No, I should know it.
Understand why?
Yes.
They have long
Lord,
conflict
he can,
to do and they should
But
put
that
on
can be
it.
deemed as having been heard, my lord, for all purposes.
Anyway, with this,
So in that bench,
all these
that
digressions.
bench he
let me
said,
come.
2 p.m. bench, that he should have been
I know
heard
Justice
before
Amanullah's
cancelling the
bench.
bench,
Anyway,
so that it should have been
Let me
recorded
come
in the
down.
order sheet that he has heard. Yes, next. Please.
because people come and have long conferences, discuss matters, and suddenly they mention without telling us. That's why I was
Yes,
complaining.
yes, you are right.
Anyway, brothers.
You are right.
Now I'm going to make 3 or 4 points in less than 2 or 3 minutes, brothers. One is we have serious objections to the maintainability of this so-called Article 32. In the highly unlikely event that your lordship issues notice, your lordship should make it clear as a caveat that it is subject to a very strong preliminary objection on maintainability, which shall be alive.
Yes.
There are judgments which say that an ED or a statutory body like the ED coming straight into a walk-in system of 32 requires very grave consideration. It is allowed in exceptional circumstances where, Malas, it is necessary that the ED is virtually remediless. That's the test. That's point number 1. I propose to raise it, Malas, strongly, both today and in any eventual hearing.
You are appealing for state of
I am for
Bengal.
1 and 3, state and
of
police,
Bengal.
state and DGP. 1 and 3, he's for 2. Point number 2, Malas. I also intend to raise the preliminary objection of forum shopping with your lordship's well-known case law, because what your lordship is concerned about is that this petition is filed after my learned friend files an identical petition. Lordship, take my word for it. The prayers are virtually identical
We are in High Court and
in
here.
High Court and here. Lordship need not waste time seeing it. Lordship, take my broadly, substantially, it's identical.
Yes.
Now you are the petitioner there, you are the petitioner here. Yes, you had a fracas on a certain day, on 9th. That cannot be an excuse to maintain a parallel riding 2 horses.
Why should it happen at
No,
all?
Malas, that's a different issue. We'll answer that. I understand my lord's concern. And don't think I don't appreciate my lord's concern. I don't think any of us hold brief that should.
Today it is this High Court, tomorrow the
No,
some
Malas,
other High Court.
sometimes, Malas, emotions go out of hand and they can't be controlled. That, Malas, please don't misunderstand me that I'm not understanding my lord's concern. And that, Malas, I don't think anybody will hold a brief. Perhaps, Malas, emotions go out of hand and we are not able to control. But the relevant test is yesterday.
No, you see, you
Yes.
should not go out of hand regularly.
No,
In an
it's not.
orchestrated manner.
And then on 9-1, again, emotions go.
Now, Malas, may I just say? We are now, Malas, talking of R1 and R3. I am saying this, Malas, that the relevant date for considering forum shopping is yesterday. I understand. I am not belittling what is falling from my lords. Keep that 9th apart for just 2 minutes. Yesterday, everybody was in court. It is not even your case that anything untoward happened or was attempted or even started. Why on earth, you having filed your own petition in High Court, the next day having filed in Supreme Court or 2-3 days later filed in Supreme Court, then make a statement to the High Court yesterday, please don't hear me, and the High Court is supposed to pass such an order, Malas? It is not that you are getting this date yesterday because of the ruckus. Kindly give a copy now. Why don't you give a copy? So, Malas, in effect, the High Court is told, I am riding 2 parallel horses. I am telling your lordship I am riding 2 parallel horses. But you please stay your hand. And the High Court records this order, 1-page order. I am adjourning it sine die. Obviously, Malas, in Committee of Courts and Superior Court and all that, Malas, it's the right thing to do. As far as the High Court is concerned, I am not blaming them. I am, Malas, on the conduct. So this is forum shopping. I again take this strong preliminary objection. My third submission is, Malas, the Panchnama, which has been read. Malas, that has been read. I am not repeating it. But just note the relevant words, only the operative words, 3 lines, which your lordship has seen, Panchnama, which has been read already. It's been read, but just the relevant lines, Malas, that's 66 to 69.
66.
Yes, 60 to 69. These words are important. That's my third respectful submission. This is relevant. Ultimately, what is relevant is this, to tell you that he snatched the papers, he ran away, he did this, he assaulted somebody. What is relevant is this, either you are lying or your petition is lying. penultimate para, second line.
Yes.
The search was conducted in a peaceful, orderly manner. Each word is important. No damage to any person or property was caused during the search. Entire proceedings were conducted in the presence of lady staff and no religious sentiments.
Leonard may read the 2 paragraphs above.
No, what peaceful
Two
means?
paragraphs
Peaceful
above.
from their side. That
I beg
what they
pardon?
mean to
2
say.
paragraphs above what my
From
Leonard
the ED side, not from your side. That is what
Yes,
I'll read whatever he wants me to read. I'll read it, Willis.
not the relevant section. Let him,
Yes,
They
yes.
have done it peacefully.
No.
let him read the 2
The
paragraphs.
previous
above.
para which he's asking
2 paragraphs
to
above.
face,
Why Leonard
respond.
may not
Mr.
do it
Raju,
peacefully.
please.
Let him read.
It is not denied by our.
Dictate Mr. Raju that what he should read.
We didn't interrupt once even, Willis.
Yes,
It took a long time.
please, Mr. Singh.
Mr. R2, Mr. Sibal, has admitted that the CM was, the president of the party was there. So what is so great about this para? This para says that so and so time, so and so Miss MB took possession of the material, etc., etc. That's all. Nobody is denying that she was there. Now, these are derailment. I am at a different point. I am saying that with this Panchnama, what you are projecting in the petition is either clearly false or your Panchnama is false. That's all I'm saying. This para is standalone, clear. Obstruction, could not do this, could not do a search, all wrong. Now, the fourth aspect is very important. My learned friend, I heard Mr. Mehta making what again is I can ascribe to mildly to wrong instructions. He said we informed them, and I believe I heard the word yesterday. The day before the event happened. I may have been wrong, I may not have heard you correctly, in which case I'm wrong. Well, it's the first and only intimation came from a casual email at.
Email can't be casual and non-casual. That's what the intimation was by email.
Have you heard my sentence fully? No, have you heard my sentence? You realize? You don't be presumptuous, Mr. Mehta. You
Casual.
started your search at 6:45. The email is 11:30. In which calendar, from which Gregorian or non-Gregorian calendar does 11:30 happen before 6:45? I'd like to understand that. So before you interrupt, get your instructions right. You're only, that's why I said, obviously, if I'm searching his house and I send an email 11:30 to create a paper trail, I started searching the house at 6:45, 5 hours earlier. And my learned friend says it was before and informed. In the middle of the persons are there, some police officer will go start reading emails. 5 hours earlier, event has happened. So this is a very clever way to cover up your tracks. A person who sends an email 11:30 for a search which starts at 6:30 is covering up his tracks, creating a paper trail to tell your lordship later on. My next point is, Willis, that the question he raised, I'm only answering that, but I'll have to put it down if necessary. I came there because a Z protectee, a Z class protectee, was informed in an FIR number 5 of 26 that unidentified persons who refused to identify themselves had entered this place and were dealing, and the Z class protectee had reached there. So naturally the police rushed there. That's all that happened. Now, the ED officials identified themselves much later. They did not identify themselves because the only identification would be a prior written intimation at 6:45 that I am Mr. A, Mr. B, Mr. C, we are going there at this time, or at least just before that. So, that is why I went there. That is nothing sinister about that. And whether she is a chief minister or a president of a party, she remains a Z plus protectee. So, the moment we come to know, we have to move.